Well, good morning, Lisbon. It is a great pleasure to be here with you today. We're all here thanks to the kind invitation of the Portuguese Competition Authority, and Nuno in particular, so I'd like to start by thanking him. Also for preparing for us such an interesting, such a topical 2 days of discussion. Really, if I look through this program, there are all of the most interesting issues that confront us in European competition law at the moment. From the interplay of competition policy with industrial policy, as we just heard, to our work, which is ongoing on Article 102 guidelines. Think about our work in the digital sphere, in antitrust, in mergers in the Digital Markets Act, or the work on the review of the merger guidelines. And I'd like to pay particular tribute to our national competition authorities today to take advantage of the presence here in beautiful Lisbon to emphasize what a common endeavor the application and enforcement of EU competition rules are. If I put that very simply, national competition authorities play an essential role. Look at the numbers in antitrust. Today, more than 85% of decisions are taken by national competition authorities, which means that the bet that we placed more than 20 years ago on a decentralized system of enforcement of EU competition law has paid off really handsomely. And that is something we can take great pride in together in our common work. Because that work is really the result of a fellowship in the European competition network between the European Commission and national authorities. And I think our European competition network is very much the engine of progress in this field. We apply the same antitrust laws, but of course the Commission and national competition authorities have complementary roles. In one sense, we in DG Comp are more focused on pan-European conduct, and our colleagues in national competition authorities are focused more on conduct at the national level. But of course that's a gross oversimplification. The reality is much more nuanced. And many of the decisions that are brought forward at national level have much wider repercussions in our single market. Nuno mentioned some of the groundbreaking work that the Portuguese Competition Authority has conducted, for example, no-poach agreements. So I think it's that flexibility in our system which has really worked well for us. And today I'd like to talk about some of the facets of our respective roles. I'd like to focus on the role of DG Comp, of the Commission in progressing and supporting the single market. And I'd like to take the opportunity to also explore a little bit some of the challenges and some of the opportunities that our decentralized system represents. So if I start with our own priorities in DG Comp, the mandate of this current Commission began very much under the influence of the report of Mr. Draghi, which pointed to a growth and a productivity gap in Europe, which identified the incomplete integration of the single market as one of the main challenges for the EU. If I quote President von der Leyen, the single market may be our greatest asset, but it remains unfinished. If you think about the statistics from the International Monetary Fund, they estimate that the internal barriers that exist today within our single market are equivalent to a 45% tariff on goods or a 110% tariff on services. So if we want to address the EU's competitiveness challenge, and believe me, we do, that has to mean deepening and completing the single market, particularly in services and capital markets, because that's what will provide the scale that's necessary for European companies to compete globally. And I think it's clear that for decades, competition policy has played a really important role in helping to support the Commission's broader priorities, always within the limit of our core mandate. And in that light, it has always been a tool to protect our single market's integration. And I think that's a role that is more relevant today than ever. And if I start in that respect with what we're doing about territorial supply constraints, in May of this year, the Commission adopted a single market strategy, and that strategy identified the 10 most damaging market barriers to the completion of the single market. Those that are holding back trade, that are holding back investment across the EU. And one of those was territorial supply constraints. These are practices that prevent wholesalers, they prevent retailers from sourcing products from other member states. And that leads to unjustified price differences across the EU. We have looked at the figures and estimate that those disparities translate into a 3.5% price increase in the price of a basket of some food categories in higher priced countries compared to their lower priced counterparts. Customers could save an estimated total of more than 14 billion euros if purchases in higher priced countries were more proximate to those in lower priced ones. And this is something that competition law can help address. We can help address those barriers, we can help prevent territorial supply constraints where they're imposed by a dominant undertaking or where they're the subject of an agreement between companies. And that's exactly why in May of last year we fined Mondelez more than 330 million euros for restrictive practices that hindered the cross-border trade of some really well-known branded chocolate, biscuit and coffee products across member states. I think these are cases that bring down unjustified barriers. They help ensure a better functioning of the single market. And this is an area of enforcement work which is at the top of our priority list these days. For example, in March of this year, we launched investigations in the drink sector, also with unannounced inspections in several member states, and also in respect of personal care products. If I turn to merger control, of course, there the protection of the single market is also a core feature of our work. We recognize the importance of scale, and you know that achieving scale is not a concern from a merger control perspective. The goal of merger review isn't to impede scaling up, it's to prevent the acquisition of market power. And I think our one-stop merger control system at the European level for transactions of a certain size is precisely designed to protect firms' ability to take full advantage of an integrated single market. Our system facilitates cross-border transactions. And so our reviews are geared towards the protection of the single market. And I'd like to talk about two particular ways in which that's the case. First, of course, cross-border transactions can proceed smoothly where there are no competition concerns, because just acquiring size isn't the same as acquiring market power. And I think the telecom sector is a good example of the difference between scale and market power. Because we need investment in the telecom sector in Europe, we need investment in other sectors too. And increasing the size of the customer base of companies, increasing their scale in a certain sense, can indeed help operators to invest. But that presupposes one thing, that's that a growing operator still has incentives to invest. And preserving investment incentives is precisely something that effective competition policy helps to protect. If we look at the research, it shows that the consolidation of mobile telecom companies in a single country tends to lead to higher prices, but not necessarily to higher investment. And that's because the reduction of competitive pressure can make it more profitable to raise prices rather than to invest in improvements, knowing that consumers don't have very many options. And that's why we intervene when it's necessary, to safeguard competition and to protect consumers. The story, of course, is completely different if you think about cross-border transactions. Mr. Letta last year in his report on the single market highlighted that cross-border consolidation allows operators to expand within the EU in countries where they're not present, and that expands their customer base and their scale. And pan-European consolidation could allow operators to gain scale, therefore, without eliminating competition between direct competitors within the same national market. There's nothing new in what I've said, and in fact, our record in this respect is really quite straightforward. We, in DG Competition, have unconditionally approved all cross-border telecoms mergers that allow such expansion over the past decade. But our action doesn't stop there in terms of supporting the single market. The EU merger regulation also puts limits on interventions by member states that interfere with transactions that have an EU dimension. Article 21 of the merger regulation, as you know, provides that member states may condition or even block transactions with an EU dimension on the basis of certain legitimate interests. So we verify that such interventions are legitimate, that they're proportionate, that they are not disguised protectionism that lead to a fragmentation of the single market. And unfortunately, there are still signs of such behaviour. I would mention the banking and insurance sector today. We need to act against unjustified measures that are adopted by governments in the name of supposed national interests and that act against cross-border EU mergers that don't raise competition concerns or that no longer raise competition concerns thanks to the effective remedies that have been accepted by the Commission. And we do that precisely because Capital Markets Union is critical for our competitiveness. We need banks, we need insurance companies that have a European scale. We need to put an end to the thinking in national silos. So in 2022, we adopted a decision against Hungary's decision to veto the acquisition of a Hungarian insurance business by the Vienna Insurance Group. And we have an open procedure over concerns that Italy infringed the EU merger regulation by vetoing the proposed acquisition of Banco BPM by UniCredit, both active in the Italian banking sector, while the Commission had already approved that transaction. It is really critical that governments allow European financial institutions to take full advantage of the single market. I think the stakes there for a capital markets union are high, and we in the Commission will act to support our markets integration. That's also because we consistently hear from the tech industry that the absence of European venture capital is a real and present danger, and we know that. We saw it again in the Draghi report. Many innovative European companies end up seeking investment from US venture capitalists and scaling in the US rather than in Europe. And again, a well-integrated capital markets union would go a long way to improve access to funding in the EU. But we can't magically change today's reality. We also noted the call of certain CEOs for more expansive market definitions in competition cases. And I would say that as the single market deepens, then market realities and our market definitions will expand. But market definition is an exercise that's grounded in fact, not an exercise that's grounded in wishful thinking. So let's change the facts first. The other side of the coin, the role of national competition authorities. I think the system of co-enforcement that was instituted by Regulation 1 is really an undoubted success, and that is very much borne out by the results of the evaluation that we conducted recently. I think the foundational principles of Regulation 1 remain really strong, but there's still some potential to increase our efficiency, to increase our effectiveness even further. And that's not least because our procedures could also do with being modernized to keep up with the pace of some of the challenges that digitalization brings for us. And that is why Executive Vice President Ribera has decided to move ahead with a legislative proposal for the updating of Regulation 1. That would allow us to address, for example, some of the Commission's investigative powers. Does it really make sense to still visit companies as if they had paper records when we know that most of the records are digital or stored in the cloud? Are our decision-making powers still up to date? Should we adapt our interim measures tool so that we can facilitate its use when fast intervention is needed? We have a very cumbersome process for granting access to file. Of course, that is the hallmark of any independent competition agency that rights of defenders are respected, but the current rules are cumbersome, they are time-consuming, and they are resource-intensive not just for the Commission, but for the companies that are party to our investigation and third parties. So in the next few months, you'll receive invitations to workshops in Brussels to really look into the details of blueprints for reform in some of these areas. All of that before we prepare a legislative proposal, as I've said, in Q3 of next year. Maybe being topical, I can open a parenthesis there with one example, which again shows how important national competition authorities are in our system of EU competition law enforcement. And that's borne out by the jurisprudence of the EU courts in Luxembourg. Because many of the key substantive developments in EU competition law in fact result from important judgments that the EU courts issue on preliminary references. Think of the Google Auto preliminary reference recently, which confirms that it's not necessary to make a finding of indispensability to order access to a platform that's been conceived and developed to be open. So like many of you here today, I'm sure you have been closely following the preliminary references arising from the Portuguese Constitutional Court's case law. and in particular the question of whether EU law requires prior judicial authorization to seize email correspondence during inspections conducted at business premises. Which is a question that raises the really important trade-off, which is inherent in inspections, between the general interest in an effective enforcement of competition law and the fundamental rights of the natural and legal persons who are subjected to it. We have different safeguards in place in different member states to strike that balance and protect fundamental rights. We saw the Advocate General issue one opinion last year that called on the referring court to ensure that breaches of EU competition rules shouldn't go unpunished. And today we've had a second opinion of the General Court, which provides additional guidance and seems to suggest that judicial mandates are not necessary as a legal safeguard to ensure the protection of personal data of individuals during inspections. And that's something I will want to look at in a lot more detail, an issue which is acutely relevant not just here in Portugal, but for us all. A final observation on the interplay between national enforcement and the Commission's own action in the field of merger enforcement. This is an area, of course, where in contrast to antitrust, we have clear dividing lines of jurisdiction. But close cooperation remains indispensable all the same, because we have different rules, but we face the same market realities, we face the same trends, we face the same challenges, and often we share the same priorities. And one of our current shared priorities is to ensure that killer acquisitions don't escape scrutiny. Because if powerful firms can acquire smaller, innovative companies that fall below our notification thresholds without any competition assessment, that represents a very clear and present danger on risks to innovation. And of course, after the Illumina judgment, the Commission can only review such transactions under the merger regulation if they're referred by competent member states. And that's why we've been really encouraged to see so many member states adopting mechanisms under national laws specifically targeted at investigating potentially problematic mergers that fall below mandatory turnover-based notification thresholds. Some countries like Portugal have market share thresholds, others have deal value thresholds, and yet others are specifically introducing or considering national call-in powers. And all of these initiatives are to be welcomed, because we rely on national jurisdiction and referrals to review mergers with EU-wide implications at the Commission. So we support member states and our colleagues in national competition authorities. We monitor transactions to identify potential killer acquisitions. We then aim to alert our colleagues in the capitals of those mergers so that they can either review them themselves at national level, or they can refer them to the Commission if they think the Commission is better placed. And self-evidently, the more member states are equipped to review such deals, the more efficient the system will also be at European level. So let me conclude. I think really that there's no area of EU law in which the cooperation and the collaboration between national authorities and the Commission works as well as competition policy. I think our co-created European competition network should be a source of pride for us all, and a system that we continue to cherish in the months and years to come. Thank you very much.